Hello, Mark Foley, solicitor here with another 3 minutes about law. Apparently, if it's longer than 3 minutes, people stop listening, and if it's about law, there's even higher chance that people are going to stop listening, so I'll keep it brief if I can. I'm having some work done at home. A new bathroom. We're spending several £1,000s, well into four figures. We've decided what we want. We're now bottoming out the contract terms. Now, it's the sort of situation I've helped clients deal with many times in the past, and this has been a bit of a learning curve for me because I've turned from being a client into being a customer, and it's quite interesting. There's been a bit of paperwork developing. I've opened a file in a usual sort of lawyer's kind of manner. Can you see that? And details of the works we've agreed arrived with the installer's terms of business on installations. Now, frankly, as a lawyer, I was expecting to see something a bit more detail. There they are. It's one page, and it's not very many words, so it didn't take me long to read. The price is fine. Not in disagreements about that at all. The payment terms are fine. Whether it's a quotation or an estimate are not clear. Is not clear. Quotation is a fixed fee. An estimate is a figure which might increase, so we're not too keen on that. It talks about remaining balance payable plus any additional work. Later on it says that please note electrical regulations are stringent. Your system might need updating, in which case an extra price may have to be agreed to carry out the work, and tiling installation costs aren't bottomed out either. So there's a bit of a chain of emails developing where these issues are being bottomed out and we're going backwards and forwards, but eventually we'll have a contract. One thing which wasn't clear to me at all is how long it was going to take. We do want to determine there about the maximum time it will take. We don't want people drifting in and out of the house at the convenience of the installer. It's very important that the terms are agreed. If you get into a dispute with anybody, you want to be able to show to a district judge what were the terms and that the other party is in breach. If it's left to oral recollections of what was agreed, it's very difficult to prove it. Since the 1st of April 2013, the limit for small claims has been increased to £10,000. Now, most people's home improvements are going to be within that limit, so the importance of that is that solicitors' costs cannot be recovered if you win your case in the small claims track. The upside of that is if you lose, then your opponent cannot get all their solicitors' costs paid either. But it does mean you're likely to end up dealing with this type of situation yourself, so it's important that at the outset you are quite clear what you're agreeing to and that it's all recorded in a manner which can be evidenced later on, an email trail or letters. If the terms aren't clear, then you're going to have to rely on the terms implied by a Sale of Goods and Supply of Services Act 1982, which themselves are not terribly clear. If you find yourself in a situation like that, come and see me, and it may be worth your while paying for some advice. Speak to you again soon.